For child support purposes, we use both parents' gross incomes to determine an appropriate child support obligation. This sometimes comes with complications. If both parents are W-2 employees working 40-hour weeks, then my job is fairly easy. In such a case, their gross incomes are easily identifiable. When a parent is self-employed, oftentimes his or her gross income is difficult to determine. Not all allowable tax deductions for income tax purposes are also allowable deductions for child support purposes. In particular, accelerated depreciation on assets is not allowed, and certain shared expenses such as phone use and vehicle use for both work and personal purposes are not always allowed. Another issue arises if one of the parents is either unemployed or underemployed. There is a presumption in the law that both parents are capable of working a 40-hour week, with certain exceptions. If a parent is determined to be either unemployed or underemployed, it is possible for the court to impute potential income to that parent. Oftentimes, this is done by establishing that parent's income equivalent to 150% of the federal minimum wage. Finally, sometimes issues come into play if and when a parent works in excess of a 40-hour week or receives bonuses through that parent's employment. There is a statutory criteria that the court assesses in determining whether or not this excess income is included in determining child support obligation. But if the overtime income and bonuses were common at the time the child support proceeding was commenced and consistent for the 2 previous years, and it appears to be steady and available in the immediate future, then these bonuses and overtime income will be included for child support purposes.